Good evening to you all and welcome again to the lectures on law of sea and maritime law. This is the lecture series for week 2, lecture 1. In the last lecture, we were discussing about the innocent passage. So, what do we mean by the term passage? Passage means navigation through territorial sea for the purpose of traversing that sea without entering internal waters or calling at a roadstead or port facility outside internal waters. Now, I would like to explain it. For example, land area and it's all here, the sea area. And let's say this is the territorial waters area. So the innocent passage will be from when a ship, a foreign ship, here this is the foreign ship, and this is trying to enter this territorial waters. That means it has to seek the permission, and that permission means through it has to declare itself as an innocent ship, and therefore it will get the permission in terms of the right to innocent passage. So that is what it is stated. Passage means navigation through territorial sea for the purpose of traversing that sea without entering the internal waters. Now, what are the internal waters? For example, there is an intent area here, and all this is the part of the sea area, and then this is again water, and this water body gets connected to a river water. Let's say there is a river here. Now, to what extent this ship can enter? The ship can enter to this area. Now, this will not enter this internal water area until it seeks special permission. So, the innocent passage, I write it innocent passage plus special permission for internal waters. That is required. Otherwise, generally, innocent passage means that traversing through this territorial water area, that is 12 nautical miles area. Traversing that sea without entering the internal waters or calling at a roadstead or port facility outside internal waters. Or if there is a port somewhere here, there can be port closer to the internal waters, there can be port outside this internal water. So this ship is requesting for a port facility. For example, it needs some repairing, there is some danger. So it can ask for the port facility up till this point. Now it can't be to the internal waters until unless the special permission is granted. Passage shall be continuous and expeditious. However, passage includes stopping and anchoring. Expeditious means it is on way to some other sea, or it's willing to, the ship is destined for some other area. So in between this coastal state, somehow it has to take a halt near this coastal state. So for that reason, it is requesting for internal waters. Continuous and expeditious. However, passage includes stopping and anchoring, but it can request for an anchor here or stopping or a temporary halt. That means it's a temporary halt in this area. Includes stopping and anchoring, but only insofar as the same are incidental to ordinary navigation or are rendered necessary by force majeure. Force majeure means under compulsion. Or that kind of passage, that kind of halt is granted by the coastal state during the normal navigation, or distress, or for the purpose of rendering assistance to persons, ships, or aircraft in danger or distress. So, under these conditions, the port facilities can be allowed, all while giving the internal innocent passage, and also in case it wants a temporary halt or it wants a temporary anchoring, so these facilities can be provided by the coastal states. Meaning of innocent passage: passage is innocent so long as it is not prejudicial to peace, good order, or security of the coastal state. Now, how do we determine the ship is requesting for innocent passage? That means it has to declare itself without causing any harm. It wants to enter the region of the coastal state area, and it kinds of promises not to create any harm. Now, what kind of harm? So it should not be prejudicial to the peace, good order, or security of the coastal states. That means it is not willing to create any armed rebellion or any kind of civil danger or it kind of civil turmoil. So all that are considered conditions for giving the innocent passage. Such passage shall take place in conformity with this convention and with other rules of international law. That means they are all subject to the granting of innocent passage, although it is derived from the customary practices, but now they are within the framework of international law obligations. Passage of a foreign ship shall be considered to be prejudicial to the peace, good order, or security of the coastal state if in the territorial sea it engages in the following activities. Now, on what case we draw the line that this ship is not in true sense innocent, or one way or the other it is breaching the conditions of innocent passage? So they are already listed. Why they are listed as per the union clause? Reason being because at some point of time this can be the question before the court of law. The ship in true sense has tried to breach the conditions mentioned under the innocent passage, or it has been for some reasons accused of trying to breach. So to know what is the real picture or what is the real position, it has to be already included in this unique clause, so that there is no such prejudice between the nations, or the laws are not interpreted favoring one nation and discarding the rights of the ships. So in the light of that, there are conditions listed in which it will not be considered that ship is complying with the conditions of innocent passage. What are those conditions? Passage of a foreign ship shall be considered to be prejudicial to the peace, good order, or security of the coastal state if in the territorial sea it engages in the following activities. Firstly, any threat or use of force against the sovereignty, territorial integrity, or political independence of the coastal state, or in any other manner in violation of the principles of international law embodied in the Charter of the United Nations. Any exercise or practice with weapon of any kind, that is the second condition. Third condition, any act aimed at collecting information to the prejudice of the defense or security of the coastal state. Fourthly, any act of propaganda aimed at affecting the defense or security of the coastal state. Fifthly, the launching, landing, or taking on board of any aircraft. Next is the launching, landing, or taking on board of any military device. So all this will be considered as conditions breaching the innocent passage. Next is the loading or unloading of any commodity, currency, or persons contrary to the customs, physical, immigration, or sanitary laws and regulation of the coastal state. Next is any act of willful or serious pollution contrary to this convention. Further, any fishing activities. Now, the fishing activities, that is without permission. It is not that fishing activities, they are totally barred under the conditions or under the conventions. But in the cases where fishing is prohibited in particular area, or there are fishes of endangered variety, or in the cases where fishing is possible subject to the conditions. So in those cases, in case the ship tries to breach the conditions, then it will be considered to breach the innocent passage conditions. Any aimed at interfering with any systems of communication or any other facility or installation of the coastal state. Any other activity not having direct bearing on passage. That means it is intentionally taken to disguise the conditions of the innocent passage, or in true sense, the ship was not in need of that innocent passage, but intentionally it has been sought for some other reasons, or it has been used for some disguised purpose. Next is under Article 22, sea lanes traffic separation schemes in territorial sea. The coastal state may, where necessary, having regard to the safety of navigation, require foreign ships exercising the right of innocent passage through its territorial sea to use such lanes and traffic separation schemes as it may designate or prescribe for regulation of the passage of ships. Now, what it says that although the innocent passage has been given from the territorial sea area, but still there can be some reservation to certain lanes for certain reasons. Now, that is subject to the rights of the coastal state, how the coastal state is willing. It is not total denial of the innocent passage, but it is what right within that territorial sea waters the ship can follow, or it's not that the ship can follow the passage according to its own choice, but it has to abide by certain regulations. So it is more like regulatory conditions imposed by the coastal states. The coastal states may, where necessary, having regard to the safety of navigation, keeping in mind the safety of navigation, require foreign ships exercising the right of innocent passage through its territorial sea to use such sea lanes, and traffic separation schemes as it may designate or prescribe for regulation of the passage of ships. For example, let's say that that sea lane is a bit dangerous, or it can be that sea lane is used for its own ships carrying heavy cargo, so that there can be risk. The foreign ship is following the same passage, so they can divert the route of the ship requesting for innocent passage. In particular, tankers, nuclear powered ships, and ships carrying nuclear or other inherently dangerous or noxious substances or materials may be required to confine their passage to such sea lane. Now, below it's also given in what conditions we impose the sea lanes, or we request the ships asking for innocent passage to avoid those sea lanes. They are the examples where there is a nuclear powered ships, or the ship carrying nuclear substance or other inherently dangerous or noxious substances, or it can be chemicals, materials that can be of danger, may be required to confine their passage to such sea lane, that they should not navigate all across, but they should follow a strict line. In the designation of sea lanes and the prescriptions of traffic separation schemes under this article, the coastal state shall take into account the recommendations of the competent international organization, any channel customarily used for international navigation, the special characteristics of particular ships and channels, and the density of the traffic. So it is not some kind of pure discretion of the coastal state, or an arbitrary order passed by the coastal state, or any such notice being issued on an arbitrary manner, or a direction issued in an arbitrary manner. Again, it has to follow certain yardsticks. Now, those yardsticks, while giving those directions to the ship asking for innocent passage, will be based or can be based on the recommendations of the competent international organizations, or any channels customarily used for international navigation. That means it has been customarily, that means from the historical time seen that this path is not followed, or mainly this path is followed by the ships, so that only that path should be allowed. Maybe the rest of the area that can be a bit more risky, or there can be other reasons. The special characteristics of the particular ships and channels, now that sometime need to be declared what the ship is carrying, or sometimes the special passages are reserved for the ships of different nature, like if it is carrying petroleum or it is carrying natural gas, so that passages are reserved for those kind of ships. So it will be risky for any foreign ship requesting innocent passage to follow that kind of passage. Why? Because in case of collision between the ships, there can be a disaster. The density of the traffic, like if there is a busy route across the territorial sea waters, like there are some coasts which are very popular, or they are very much frequented. So to avoid those traffic congestion, or to avoid those risky movements, the innocent passage that is requested, that can be diverted in some other directions, or those ships can be requested to follow some other routes. The coastal state shall indicate such sea lanes and traffic separation schemes on charts to which due publicity shall be given. It should be declared a priori. Reason being, because the ship that has requested the innocent passage knows in advance which route should follow, or which route it should avoid. And that should be properly covered, or let's say properly drawn in the chart, so that it's traceable, or it is navigable by the ships that is following the innocent passage area. Now, there is a famous case of Bay of Bengal maritime boundary arbitration between Bangladesh and India. Firstly, I would like to show you the map here. This is one of the very complex case of territorial boundaries, and that also across the Bay region. Now, what is the Bay region here? You see, this is all India here up till Tripura. This is also again India, and this follows the Bay area. You see here the Bay of Bengal. Again, this is the third country, this is Myanmar, and closer to it is again Mizoram, Indian part. Now you see that Bangladesh is surrounded by India, and then also it's Myanmar. How the area can be divided? The Bay of Bengal area, we have to draw the territorial boundaries, territorial sea across this Bay area. And then there are small islands which we can see here because it forms the delta between India and Bangladesh boundary. There is a delta, the Sundarban delta. So we need to decide what part of the delta should be with Bangladesh and what part of the delta should be with India. Now this led to a matter of international law. Earlier, there was no such dispute, or let's say there was no such issue. Dispute would not be the right word because it has not escalated to the extent of bitterness between the two nations, but there was disagreement between the two parties, that is India and Bangladesh, with regard to their boundary measurement. Now, why this issue arose? Because earlier, the Bangladesh was termed as East Pakistan because it was part of the Pakistan. And the boundaries between India and Pakistan, which includes East Pakistan, were decided by the British people when they left the country. And at that time, it was agreed between the parties that this will be the kind of boundary between India and the Pakistan, which includes East Pakistan. So there was no such issues because these ports were less frequented by the Pakistan government, the earlier Pakistan government. But when later on Bangladesh became a new independent country, so it wanted that its own territorial water area, its own continental shelf area, its own contiguous zone. So they were not ready to accept the earlier agreement made between India and Pakistan through the British negotiators. So they wanted a separate agreement to be made between India and Bangladesh that will decide finally the boundaries. Now the question of boundary became more complex, reason being because it's not a straight line division between India and Bangladesh. Here it's all patchy and porous region we can see here. And beside this there are a web of rivers and their tributaries following from the Indian side and also from the Bangladesh side that are merging to this bay area forming delta. So how that can be now divided between the two states was questioned before the international court or the international arbitral tribunal. Now you can see here the one side it's India and the other side is Bangladesh. Main river that are in contention, that is Haribanga river and Raimangal, and this Newmore island which Bangladesh has been claiming as part of its own territory. That is another issue. Another map shows here Bangladesh, and I have surrounded, this is south 24 Pargana, this is north 24 Pargana, which borders water body, and that water body is the partition line between India and Bangladesh. And now here it is Raimangal river, this is Khulna district which falls under Bangladesh, which is part of the Bangladesh, and it borders this water body that is formed by combining several tributaries are combined that again merges with the Bay of Bengal. So firstly, the boundaries between India and Bangladesh is through the lines that is drawn. You can see here the dark blue line that divides the part of, on one side it is India and one side it is Bangladesh. So this water body is again divided between India and Bangladesh. You can see here this, and this water body is formed out of several tributaries that makes. So the tributary of Ganga also, tributaries of, this is actually Ichamati, Kalanidhi, mixture of Ichamati and Kalanidhi river, and this is, above is the river Ganges, then is another river is Jamuna river from Bangladesh, then is another river called Bichura river from Bangladesh, and this all falls, this borders district Khulna of Bangladesh, and here on the Indian side it is north 24 Parganas and south 24 Pargana borders this boundary. So you can say that the boundaries, the land boundaries of north 24 Pargana and south 24 Pargana, they are extended to the extent of this water boundary, to the midpoints, or even they are not exactly the midpoints, but the line that is drawn in between this water body is extended to that extent. And the boundary of this district Khulna is extended further to this water body area. I mean to this point. This is the Bangladesh extension of the Bangladesh waters, Bangladesh boundary, and this is the boundaries of Indian side. And how this tributary is formed? It is after combining several rivers both from the side of India and from the side of Bangladesh. And after this, it merges with the Bay of Bengal. You can see in this map here, that is how it merges with the Bay of Bengal. Next is another map that shows the delta, how these deltas are formed because of several tributaries from the Indian side and from the Bangladesh side. And the question is, these tributaries, this delta position forms various islands. These islands have to be divided between Indian side and the Bangladesh side. So how that will be divided? That's another complex question here. Next is the map of Bangladesh and India, combined map of India and Bangladesh here, which shows how the Bay of Bengal forms the coastal region across both the Indian side and the Bangladesh side. So the arbitral tribunal was constituted under Annexure 7 of UNICLOS to decide the matter between India and Bangladesh in the matter of Bay of Bengal maritime boundary arbitration between the People's Republic of Bangladesh and Republic of India. What were the main issues? The issues were in its award dated 7 July 2014, the tribunal unanimously decided that it has jurisdiction to identify the land. The first question was whether the arbitral tribunal is entitled or it has the jurisdiction to decide the matter or not. So it decided that the tribunal has the jurisdiction to decide the matter because it was earlier agreed between the parties that in case of the disputes, they will go to the tribunal. It has jurisdiction to identify the land boundary terminus and to delimit the territorial sea exclusive economic zone and continental shelf between the parties within and beyond 200 nautical miles in the areas where the claims of the parties overlap. So, as per the UNICLOS, the arbitral tribunal does have the jurisdiction to decide the issues that are pertaining to territorial sea area, exclusive economic zone area, or the continental shelf area, whether that is within the 200 nautical miles or beyond the 200 nautical miles, and where the parties, their claims or rights are overlapping. Bangladesh and India agreed that the location of land boundary terminus was to be determined by application of 1947 award rendered by Sir Cyril Radcliffe, chairman of Bengal Boundary Commission, as well as notification number 964, jurisdiction of Governor of Bengal 1925. So both the parties agreed that the earlier text, that is the earlier records that were prepared by Sir Cyril Radcliffe, who was drawing the boundary across the eastern frontiers, will be accepted, and the award that was given at that time will be considered for the purpose of references. And while giving that award, the views of Governor of Bengal at that time will be taken into consideration. The Radcliffe Award drew the boundaries between India and the new state of Pakistan, the eastern portion of which subsequently became Bangladesh. So at that time, when the boundaries were divided between India and the Pakistan, which later on became Bangladesh, that was taken into consideration for references. It provided in Annexure A that the boundary line shall run southwards along the boundary between district of Khulna and 24 Parganas to point where boundaries meet Bay of Bengal. So as we have seen in the maps that on one side it is district of Khulna, which is on the Bangladesh side, and then there is 24 Pargana, one north 24 Pargana and south 24 Pargana on the Indian side. And there is a water body that divides between the two, so in between the points will be drawn. Those points will be the boundary division between India and Bangladesh. The boundary between districts of Khulna and 24 Parganas referenced in Radcliffe Award had itself been set out in 1925 notification number 964 Jure in following terms. The western boundary of district Khulna passes along the southwest boundary of Chandanpur till it meets the midstream of the main channel of river Ichamati, then along midstream of main channel for the time being river Ichamati and Kalinadi, Raimangal and Haribanga till it meets the bay. Now why it says here the midstream of the main channel of river Ichamati, then along the midstream of main channel for time being river Ichamati and Kalinadi. I get back to the map again. If we see this map, now this is combination of Kalinadi and Ichamati river, and at the top is river Ganges. Now this is formed out of the tributaries, and these tributaries keeps on changing the course. So sometime it will be more towards this 24 Pargana, sometime it will be more towards Khulna district and Chandanpur district. Now that means how we will determine what is the exact boundary between India and Bangladesh. It's difficult because this year it has gone more towards the Indian side, like it has gone in this way. So it has covered more of the Indian land and less of the Bangladesh land. So it goes like this. And the next year it has taken more of the this way and more of the Bangladesh side. So how we will determine the boundaries in true sense? Therefore, it was decided that it was not decided on the based of the midpoints between the two, but keeping in mind the midpoint of different rivers. So, if we draw the midpoint of Ichamati, if we draw the midpoints of river Kali Nadi, and we extend those midpoints. So that will be how the borders between the two nations will be decided. The boundary between the district of Khulna and 24 Pargana referenced in Radcliffe Award had itself been set out in 1925 notification number 964 Jure. In the following terms, the western boundary of district Khulna passes along southwestern boundary of Chandanpur till it meets the midstream of the main channel of river Ichamati, then along midstream of main channel for time being of the rivers. Time being means they keep on changing their routes. Ichamati, Kali Nadi, Raimangal and Haribanga till it meets the bay. So it will, that midpoint, midstream area will be continued to up till the point they meet where the bay starts. The parties disagreed on the interpretation of Annexure A to the Radcliffe Award and of 1925 notification. They also disagreed on the relevance and interpretation of the map in Annexure B to the Radcliffe Award. Delimitation of territorial sea. Both parties agreed that Article 15 of the Convention governs delimitation of the territorial sea in this case. That provision provides for boundary between two states with opposite or adjacent coasts to be the maiden or equidistant unless historic title or special circumstances apply. So, as the unique law states that the usual method is to draw the median point or the equidistance, or if the historical title, or the another condition is the special circumstances should be taken into consideration while drawing the boundary. So in this case, it was the question of special circumstances should be considered. The special circumstances were because of the curve of the bay, and secondly, the rivers, they were very dynamic in nature. They were always changing the course. So in that reference, it was difficult to draw a static boundary between the two nations. Therefore, it was considered that we need to apply the special consideration rules or the special provisions for deciding the matters of boundary division between India and Bangladesh. It was very interesting that you have been participating and listening to these lectures. I thank you very much for being listening to these and giving time for the lecture. We continue further on the same India and Bangladesh maritime boundary dispute. Thank you very much.